Okay, so we are looking at mortgages today, and I'm going to aim to keep this reasonably brief. I'm aware that my lectures have been running over slightly, so I'm going to just try and keep to this being quite a clear and simple, accessible introduction to mortgages, because I'm very aware of the fact that we're going to use these 2 weeks to really dwell in it for a while, because next week is your formative assessment. So the content from this week's lectures are going to form part of the seminar the week after next. So just to clarify, next week your seminars are going to be used for the formative assessment. So the lecture material that we're covering now, lectures 11 and 12, will be combined with 13 and 14. So basically you'll have 4 lectures on mortgages, but still just one seminar, and that will be, or the usual sort of 2 hours, 2 seminars together, and those will be the week after next. So we'll be into week 8 by the time you need the information from these lectures. So you're going to have to kind of put this week and next week together. So week 6 and week 7's lecture content you're going to have to put together, and then we will do the seminars in week 8 on mortgages, just to be clear. So this is just a simple introductory session to explain mortgages, which shouldn't be massively complex, as we've already considered situations in our registered land seminars as to when somebody will have this type of interest. So the interest in the land itself being given to the bank in return for money, and we've already looked at that as a legal interest or an equitable interest, how then those things would be evidenced in terms of document and registration. So some of what we're going through today, don't know why that's like that, but what we're going to do today is to look at some of that in the context of thinking about a mortgage as a form of security, so a secured form of loan. So we're thinking about loans as in regards to a mortgage situation. So the mortgage is the interest in the property in return for money, but it's basically a form of loan agreement. So that's acting as security. We'll look at why mortgages are as important as they are in the UK, because of the significance of the idea of home ownership, in contrast to other areas, other parts of the world where it's not the norm. But in the UK it has become the norm, and very much something to aspire towards. So we'll look at the role of the mortgage in allowing that to happen, because people aren't able to afford to buy their own homes outright. So that capacity is only possible through a loan from the bank. We need to understand the terminology, so we should be reasonably comfortable with that already, but we're going to make sure that we're clear on what aspects of a mortgage's problem question you need to know, as explaining who the parties are and what it is that they've got. We'll look at creation of both legal and equitable mortgages. So both exist as entities in land law. It would be highly unusual to have an equitable mortgage, but they do exist. So we will look at both of those. Obviously then remembering that we've got a form of interest that then is documented a certain way and would have to appear at land registry. So all the stuff we've been doing together so far, we would just kind of cap off again for mortgages, the same ways we did last week for leases. And then what I want to do is start to talk about the sessions that are to come. So we will have 2 sessions on mortgagees remedies, the remedies available to the bank and their role in this. So we will look at the bank first, because as you'll come to see, the remedies that are available for the borrower, the mortgagor, those are really only in response to what it is that the bank can do. So I appreciate some textbooks deal with the borrower first and then deal with the bank. However, I'm going to deal with the bank first and then look at how the borrower can respond to some of the things that the bank is doing. So that's the line of attack I prefer to use. I think it makes more sense if you know what it is that the bank can do, and then see how the borrower responds to that, rather than just thinking of it on its own. It doesn't really make sense to me fully. Okay, so we're looking at a mortgage as a form of a security. So the function of a security obviously is to allow a lender to provide money with the security or the knowledge that they have an asset. So we have a security given to a lender that acts as for some form of protection for them. It's an asset that the lender holds on to in return for the money. So we have that in a variety of settings. Some form of asset given to or power over the asset given to a lender in return for money, and the asset being returned, or true ownership of the asset vesting in the borrower on repayment of the monies. So that's what a security does. It gives the lender literally a form of security that they can lend in return for an asset. And that's different from an unsecured loan. For example, any form of personal loan or credit card, overdraft, anything like that would be unsecured. You aren't giving the bank anything in return for that money. So you would apply for a credit card, you would apply for an overdraft, you would apply for some sort of credit on an account, and that is being given without the need for you to put up any assets. The bank are just trusting you to make those repayments. They'll do a credit check and ensure that you are able to, that you look like the sort of person who would be able to keep up with that. And as your trustworthiness grows, the amount that the bank will entrust to you will grow as well. So that would be a completely unsecured loan. A credit card, overdraft, it's the most simple way of looking at it. Versus a secured loan, so some form of loan that relies upon a security. So that the truest example usually is car finance. If you think about the car belonging to the finance company and you making those payments, they are retaining ownership of the vehicle until you have completed the finance agreement and returned the money to them effectively. So yes, you might drive out in a shiny new car, but it's never truly yours until you have finished paying for it. That is a secured loan. The finance company can come and seize the asset, can take the vehicle if you don't keep up with the payments. So two different forms of security, two different forms of loan agreement there, one being unsecured and one being secured. So the security could therefore link to the person or the property. So the security would usually be in some form of property that we would recognize. So whereas property lawyers thinking about the security linking to land here in land law, but I've just given you an example of personal property security. So in that situation we could see that a car, mobile phone contract, so you're paying partly for the usage of the network, but you're also chipping away at the cost of the handset itself. So that is some form of security that you have. The company can take the phone from you, or a laptop, or a tablet, or a car, or whatever, if there's not payment kept up on that. And also, quite clearly, it's possible to attach security to land and to property in that way, so real property. So intrinsically, a mortgage is just one form of security over land. It's the interest in the land itself that is acting as the mortgage. The money is still just money. So whenever you hear about somebody saying they're going to go get a mortgage, they're not going to get a mortgage. They're giving away the mortgage. The mortgage is the interest in the land, and they're giving that as a form of security to the bank in return for the money. So the money's being transferred on the condition that the bank have the asset. They have a percentage of the land that they can therefore lend securely on the basis of. So that's just a bit about securities. So the most kind of recognizable one for you guys so far might have been some form of car finance. It's definitely built into your mobile phone contract. You might have an overdraft or some sort of unsecured loan like your student loan. That's against you as a person. But here we're thinking about linking security to property, and we're obviously as landlords considering it in the context of a mortgage where the interest in the property is being given to the bank in return for money. So the mortgage has become the norm really in the UK due to the drive, really the societal drive and pressure to become homeowners in this country. Pettit and Pettit isn't a mortgages case as such, it's a co-ownership case, but Lord Diplock in Pettit and Pettit relates to the fact that Britain has become a property, particularly a real property mortgaged to a building society owning democracy. So what he's trying to say there is not that we just are all owners, that we are only enabled to be owners. So our real property ownership is hinging on the fact that we have had to create a mortgage in the land to either a bank or a building society in order to make that happen. Oldham relates to this as well. He recognises that, so this is an academic Oldham I'm referencing from his article on mortgages in Land Law Issues, Debates and Policy. He states that the purchaser acquires a sense of belonging not only to the neighbourhood in which the house is located, but also to a larger group of homeowners generally. Home ownership signals respectability, responsibility, and usually also upward mobility. The particularly English ideology surrounding home ownership has had the result that non-homeowners have become almost second-class citizens, and we can see this distinction very clearly evidenced in the UK that isn't apparent elsewhere. In places like France and Germany, tenants have really strong rights and really firm attachments to the land that are very hard to override or to overcome. Whereas here, that norm has been translated into ownership. So the protection for tenants is actually quite low as regards safeguarding tenants in the UK. Things like rent rises, things like conditions of property, etc., are very, very low compared to the rest of Europe. Statistically, then we can look at that and evidence it. So you guys are going to be asked to do presentations that have support in them. I've just given you some support from some case law, also given you an academic opinion, and here I've got some data. So I've got data that supports this notion of how important and significant the mortgage is in the UK. So the figures given most recently from the Communities and Local Government website would be that 14.6 million households in England, so that's 68% of all households in England, own their home. That's massive compared to other parts of Europe. That is huge. Obviously, then, of that 14.6 million households, 11.1 million currently have mortgages. They may have had mortgages previously and paid them off, but we're still talking about a huge percentage of people who have got some relationship with a bank and some hold in the land given to a bank. According to the Bank of England, at the end of March 2016, the total value of residential loans in the UK exceeded £1,304.5 billion. So we're talking about £1,304.5 billion outstanding in terms of residential loans owed. That's the Bank of England Mortgage Lenders and Administrators statistical release from March 2016. So we can see that this is huge in terms of a financial hold and the drive behind economic expansion within the UK, that the banks have had to have a key voice and are therefore, the party that can put themselves on the register twice. So we've got mortgages constituting what Oldham refers to as a key economic institution. They allow assets to become mobilised, they allow capital to be generated, and therefore they boost the economy. It's seen as something that makes land active and creates value. What can happen though is that reliance on the concept of something like a mortgage to fuel your economy means that it if it falls, it takes a lot of other things down with it. So we can see in 2008 that there was an economic crash. The banks all over the world have crashed, and we had a huge financial recession that we've never really recovered from. And mortgages really were key to that crash. We had what was called and referred to as subprime lending, and that's where you would have lenders who were creating agreements with people knowing really that their credit history was poor. So we would have situations where I've already told you, and it may now be harder for all of us as a result of this stuff. You have to face a credit check for a mobile phone contract, you have to face a credit check for a car finance, for a couch. So you've got all these situations where your personal credit history is being examined and explored, and that should be even more so when we're dealing with the sort of debt or the sort of financial impact that there would be behind signing a mortgage agreement. And here we had lenders obviously financially benefiting from those agreements, and bankers definitely wanting to hit targets and gain commissions, etc. So we had what's referred to as subprime lending. Lenders were becoming irresponsible with their lending practices. They were lending to people who clearly couldn't afford to keep up the repayments. They were also allowing people to take out mortgage agreements with a very minimal input themselves financially. So we would have the existence of the 99% mortgage or the 98% mortgage, where somebody would only have to give, if you're looking at a £200,000 house, people would only have to find £2,000 in order to have a 99% mortgage. Now, obviously, that's not going to be sustainable. You don't have any real risk there. If you only have to find £2,000 and you end up with your own home, and no one's done a proper credit check on you or thinks, oh, you'll be okay, then what's going to happen is you're going to struggle to be able to keep up with these repayments. You're not really that invested in the property because you only ever put £2,000 into it. And then when it goes wrong, it's quite easy for you to walk away. And that's really what leads then to the financial crash. Property prices plummet, people walk away, they can't keep up the finance that they've signed for, and the banks crash. So we can see that the financial crisis in 2008 is really brought about by this reliance on the mortgage as a key institution for our economy, for everyone's economy. And now what's happened is, unfortunately, as a result of that, we all now as a generation have to suffer. So it's impossible pretty much to get a mortgage without a 10% input of your own. So for that £200,000 house, we're now needing to find £20,000 of our own, which is a big ask. It's a lot to save up. So we have a 95% mortgage for certain key workers with some help from the government. But for most other individuals, banks are now requiring you to find 10% as a deposit. The checks and balances that are going on in order for you to be able to sign that mortgage agreement are far more stringent, and you have to be purer than pure to be able to be given a mortgage agreement in this country now. So it's just made the whole situation very difficult for first-time buyers and for young people to get onto that property ladder that we've seen is the norm in this country. Which means that with that difficulty, we have a lot of people who are now becoming tenants, who have no choice other than to become tenants, and we have little protection, unfortunately, for them because our system in this country isn't built towards that. It's not structured in a way that would protect tenants. So that's how significant some of this stuff can be socially. And I'm trying to give you some opportunities that if you wanted to do a presentation that's a bit more interesting in terms of what's going on in society, that you have that. I ideally I'm going to frame the presentation guidance in a way that asks you to think about stuff we've covered on the module. You know, don't go beyond the pale of the module contents as such, but it's still quite possible to weave a social tale or to look at politics and the impact on society within some of the concepts that we're exploring on the module. And definitely mortgages is an area that is ripe for that. Okay, so then moving on to the kind of more descriptive stuff, we have to work through our definitions and the aspects of mortgages that we have to become comfortable with. So we know that the mortgage is the interest in the land itself. So mortgage is the interest in the property. The mortgage is the percentage of the property that is given by the mortgagor to the mortgagee as a form of security for the repayment of a debt. So the money will be given to allow the house to be bought. The mortgagee will put up the part of the house as security in order to achieve that. And then there's a provision for redemption. Redemption means you get it back. So the house will go back to the mortgagor. Sorry, I think I've confuse the terminology myself there. So the mortgagor is the borrower. The mortgagor will get the property back from the mortgagee on the repayment of the debt. Mortgagor, as I've said, is the borrower. So the mortgagor is the person putting up the interest in the land as security. The mortgagee is the lender, so usually the bank or the building society. They're the person who holds that interest in the land, provides the money, and will give the property back whenever the money is returned. And then that provision for redemption, the redemption is the ability to free the property of the mortgage interest, free the mortgagor of the mortgagee by repaying the debt. And that debt is broken down over time. It's usually 20 years. And the interest will be built into the debt as well. So you'll have monthly payments being made against a 20-year debt. And then there will be other things written into the contract that we'll look at, such as if you wanted to redeem early and for yourself, if you had some sort of windfall and were able to repay, how would that work? Okay, so historically, before the Land Registration Act 2002, the creation of a legal mortgage was allowed through what was recognised as basically a long lease. So the bank almost became like a tenant. Their hold in the land was as important as a long-term tenant, with a provision that would cease, say, on redemption. So with a provision that they would no longer hold that lease when the debt was repaid. So that was recognised in Section 85(1) of the Law of Property Act 1925. It was the mortgage of the fee simple by grant of a long lease. So it was basically the fee simple absolute and possession holder creating this hold over the land by recognising that the bank were like a leaseholder. They were holding the property as if they were a tenant, and the mortgagor would only get that back when they had repaid the debt. So it would stop, say, on redemption being repayment of the debt. The other way of doing it was the mortgage of the lease by the grant of a sublease. So if the mortgage related to a lease itself, remember you might have a mortgage over some of these long leases themselves, 99-year lease. You might, in order to sign that agreement, need to borrow some money. So therefore the bank would become, if you were a tenant, the bank would become a subtenant. So that's the idea, that the bank were, in the eyes of the law before the Land Registration Act 2002, as significant a party as if they were a tenant of the land, that was the extent to which they would hold it. Now, however, the modern way of looking at it is a charge by deed by way of legal mortgage, and that is under Section 87(1) of the Law of Property Act 1925. And that's the only way possible now in registered land. So under the Land Registration Act 2002, that's the only way we recognise a legal mortgage. So that previous way, the long lease that ceases on redemption, that's only available in unregistered land. They may exist in unregistered land, but in registered land, which is what we're dealing with, this is the only true way to create a legal mortgage, and that's a charge by deed. That's what we've been doing so far the whole way through. Section 12C of the Law of Property Act 1925 recognising a legal mortgage, Section 87(1) saying that that is a charge by deed by way of legal mortgage. So that's the creation of it. What that would look like within the deed, so you guys are always saying to me, what does a deed look like? What will the deed say? The deed would have this information in it. The borrower charges the property by way of legal mortgage with payment of all the money payable to the lender under the mortgage conditions. So if you can recall from contract law, what it's doing there is it's incorporating other documents into the deed. And those will become similarly binding because the deed has been signed and is a legal document. It relates and refers to conditions, so the terms of the agreement are within the mortgage agreement itself. So you might have this massive document that is your mortgage agreement, and has got all the conditions and the terms and the payment schedule and all of that stuff written down. But by incorporating it into the deed, it becomes legally binding too. So this is what it will say in the deed. So it refers to the charge over the property. It refers to it as a legal mortgage. It recognises that there has to be payment of money, and it recognises those conditions. So that's all incorporated within the deed of mortgage itself. So this, under Section 87, gives the lender the same protection powers and remedies as if the mortgage had been created under the provisions that I just said existed before that. So in the eyes of the law, this power under Section 87 recognises the bank as the same holder as if they were a tenant. Now, if you can remember back to, and you should have it clutched to your bosoms, Section 11A of the Law of Property Act and Section 11B of the Law of Property Act recognise two legal estates. Then we've got Section 1(2), which relates to legal interests. What this clause is doing, what this section of the LPA is doing, is effectively saying that although a mortgage is a legal interest under Section 1(2), it's giving the lender the same rights, really, as if they were a tenant, so as if they had legal estate. Again, this is all kind of points of interest stuff. It's just getting you to recognise how significant a hold the bank have in the land. So whenever we're looking at a problem question, you're thinking, why are they allowed to do that? Or why have they got so many rights? Or how come the court are going to allow them to take or behave or do in all of these situations? The answer is just always clear, because Section 87 really puts them up there, the same as if they were the owner and or a tenant, with a long lease. They are up there with legal estate in the eyes of the law. And that's the only recognisable method under Section 23(1)(a) of the Land Registration Act 2002 for a party to have a legal mortgage in registered land. So Section 85(1), 86(1) are interesting from an historical perspective, that's and when Section 87 relates to it being like Section 85(1) and 86(1), you've got to know what that means. But actually, under registered land, which is what we're focusing on, Section 87(1) is the only way that we will be looking at making a mortgage happen. So what formalities then are needed shouldn't be any big mystery to us because we've covered it repeatedly. So obviously, as a legal estate, we will need a deed. So the reference there is to a legal mortgage. So we should recognise that a legal mortgage would need a deed under Section 52 of the Law of Property Act 1925. Again, knowing how to attach and affix it and to make it legal, it will have to be registered as a registrable disposition under Section 27 of the Land Registration Act 2002. So if the borrower's title to the land is registered, if it's registered land that we're dealing with, then the mortgagee has to register the mortgage as well. If it is the first time that we have a mortgage and we're relating to unregistered land, then it will trigger that land to become registered. We know that it's a trigger for first registration. So again, recognizing this significance, if the land has been sold, that will have triggered registration. If the land is unsold and we have a first mortgage here on unregistered land, then that will become a trigger for registration. Equity, obviously, the evidentiary requirements are different. We've looked at that previously. So in terms of equity, there will be a contract and not a deed. Could be an actual contract or there could be a defective deed. So there's either no deed evidenced or the deed is defective in some way. So we're still going to need a form of writing. We're going to need some evidence that this has been written down. It has to comply with the terms of Section 2 of the Law of Property Miscellaneous Provisions Act 1989, as in it's in writing, signed, and contains some terms. Is enforceable against the parties, so there has to be some evidence of how it would be performed and enforced. So again, thinking about terms, payment schedules, dates, etc. Or if it hasn't been registered under Section 27, then it will still become an equitable mortgage. So that was the final hurdle, if you're thinking about it like hurdles of negligence, that was the final hurdle we needed to cross to affix that legal interest to the land. If we hadn't registered it, then it's only ever going to be capable of being an equitable mortgage. Or it's a mortgage of an equitable interest. Now that's going to get very difficult to bend your mind around, but it would be where somebody has created a mortgage over their own equitable interest. That's usually a beneficiary. So beneficial interest under a trust, they might create a mortgage of their share. So they will give their share to the bank in return for money. And where that has happened, that's only going to be an equitable mortgage. So say, for example, we had 3 people who had purchased together. If one of them wanted to sever their hold in the land and split out their share, they could effectively do what they wanted with their share. They could sell it to someone else or they could create a mortgage over it. And that's possible for them to do. Obviously understanding that then the lender comes in as a third in effect. They don't ever take total control over the property. So that would also be capable of being an equitable mortgage. So what does it look like then within the mortgage? What sorts of agreements do we see between the two parties? They usually include obviously the schedule for repayment, so over what time period should the loan be repaid, such as the breakdown of how many years, the breakdown of the monthly amount, the provision for some of that to be interest, etc. So you will have all the financials evidenced within the mortgage agreement. You will also have covenants or promises, contractual promises made between the mortgagor and the mortgagee in relation to the property. So the mortgagor will have to behave in a certain way as regards the property. They will have to keep it maintained to a certain standard. They will have to insure it, and they will have to be careful as to who they rent it out to if they're allowed to. Now that all might sound quite severe, but you have to understand that fee simple absolute possession nature of their hold has been totally qualified by them allowing the bank to have this relationship with the property. By giving 90% of the interest in the land over to the bank in return for 90% of the money needed to buy it, they only own, the true owner in the eyes of the law kind of only owns 10% of it. So it's really the bank's asset, it's the bank's security. So the bank will make the borrower behave this way, will make sure that the asset doesn't depreciate, will make sure that if the asset goes on fire that there's some insurance, will make sure that the asset isn't going to be rented out to Twitchy the Tramp and left, rot and be destroyed. So the bank will very clearly evidence that they want the property looked after in these ways because it remains their asset until the debt is repaid. And as well as that, you will see how the bank can behave. So how the bank are intending to resolve any situation. So you'll have all those rights and remedies that we're about to very quickly touch on set out within the mortgage agreement itself, such as these. So these are the mortgagee's remedies that we're going to cover in the next lecture. We're going to start to cover in the next lecture. So we're primarily looking at repossession, possibly starting to touch on sale. So we've got these kind of remedies to work through. The first one being quite key in terms of securing an empty property in order to then sell it. So the power of sale is usually very difficult to exercise if you still have your mortgagors present on the property, and it also makes life incredibly uncomfortable. So the first step for a mortgagee where there's been some sort of failure in the covenant to repay will be to secure an empty property. So that's where repossession would start. So we'll look at how a bank secures an empty property. How do the bank repossess the land effectively? They're repossessing it then to sell it because they have an asset that they have been able to realise if their debt isn't being repaid. In these situations, the debt won't have been repaid. They will want to sell the asset in order to repay some, all, whatever of it. Foreclosure we're not going to deal with because it's quite archaic, and you'll see that under section 90 the mortgagee usually now has the ability to apply for sale in a more easy fashion. So that means that foreclosure is very rarely used. It's quite archaic. It's quite harsh. So it's like forfeiture in that it deems that the mortgage agreement has been broken and it declares it null and void. So it completely extinguishes the borrower's ability to have any hold in the land at all, and it transfers the mortgage, transfers the property completely to the bank, free of any rights of the mortgagor. So say for example the property had any equity in it or value in it, then the mortgagor isn't going to get or see any of that, because foreclosure would extinguish their rights. It's as if the contract didn't exist and they didn't exist, and the bank would just seize the land. So quite archaic, very rarely used. What will happen instead is the bank will repossess and sell, and then if there is any equity or value in the property, it will go to the mortgagors. Obviously, there will be there will have been, same with any process, there will have been administrative fees racking up during the repossession proceedings, etc. So it's unlikely that they'll get very much, but possible, whereas in foreclosure they just wouldn't. Appointment of a receiver is usually used in situations where the property is going to be continually used in some way, so a receiver would therefore take over the day-to-day management of it. Quite unusual, usually only used in commercial property where the bank won't want responsibility for the asset or for the property in some way. And again, not something that we're going to go into in any detail, but it is a remedy available to the bank that they can take over the property and put a receiver in to manage it. The main one always remaining the promise to the key promise, the key covenant between mortgagor and mortgagee of this covenant or promise to repay the debt, basically, and that will remain as a debt. So if the property is in negative equity and the amount left owing isn't enough to satisfy the bank, so say for example it was £180,000 owing back to the bank, and the property is only worth £150,000, the bank therefore still have the ability to sue the borrower for that other £30,000. There still is a promise to repay it. It becomes an unsecured loan. It just becomes a debt. The property's gone, so it's not secured anymore because the property didn't meet the financial needs of the debt, but there still is a debt. So it translates from being a secured loan that the security's gone for, and now would still vest as an unsecured loan. So somebody could still have the need to pay off the bank, even if they have they've been repossessed, they have no property anymore. They will be indebted to the bank and have to find some way to satisfy that debt. So that's where we're headed next. We're going to look at the bank's rights and remedies first, and then look at how the borrower can respond to some of this if their situation. So yeah, I wanted to, and I believe we have, crikey, I don't know why I don't have all of my information there, but we've looked at what a security is, we've looked at the importance or dominance of mortgages in the UK as an economic structure, we've considered the terminology, we've looked at legal and equitable mortgage creation, we've also looked at registration, and covered an intro, a very brief intro to mortgagees' remedies. Thank you very much.